Good afternoon, and thanks for joining the ACLU of Virginia for a Facebook Live discussion about targeted regulation of abortion providers. My name is Bill Farah. I'm the Director of Public Policy and Communications for the ACLU of Virginia.
And my name is Gail Dady. I'm the Secular Society Women's Rights Legal Fellow for the ACLU of Virginia.
And thanks again. This is an important topic in Virginia. We've had some recent developments that the public should know about, and we want to back all the way up a little bit before we get to talking about trap laws. Well, let's talk a little bit about abortion in general. And I think the first thing, legally, everybody knows Roe versus Wade, right? But talk a little bit about what that means. Maybe some people don't fully understand.
Sure. So in Roe versus Wade, which was decided in 1973, the Supreme Court of the United States held that the Constitution protects a woman's right to decide whether and when to become a parent, even if that includes terminating a pregnancy. Okay. And what Roe established was essentially what's called the trimester structure, was that if a pregnancy is in its first trimester, then the decision about whether to terminate a pregnancy and how that's done is between a woman and her doctor. Then during the second trimester of pregnancy, the state can regulate the abortion procedure to the extent it's necessary to protect a woman's health and safety in her life. And then in the third trimester, which is what was called after viability, so after a fetus would be able to survive on its own outside the woman's body, then at that point the state can prohibit abortion altogether, or say that it's only to be performed, so long as it can be performed still to save a woman's life or protect her health. So that was the standard. It was a strict standard for the 70s and 80s. And in 1992, the Supreme Court revisited abortion in a case called Planned Parenthood v. Casey. And in that case, the Supreme Court revised the standard that was set in Roe for a court evaluating whether a restriction on abortion was constitutional. And so what the court said was that states were allowed to restrict abortion during the first trimester, so long as it was either one, necessary to protect women's health and safety, or two, to make sure that a woman has the amount of information necessary for her to make an informed choice. And then also the state is allowed to try and persuade a woman to choose childbirth over terminating a pregnancy. Okay. But there's a caveat to that standard, which is known as the undue burden standard. And that says that if a state is going to impose a restriction on abortion, then that restriction cannot impose a substantial obstacle to a woman's ability to access safe and legal abortion. Okay. And if a regulation is not necessary to protect a woman's health or life, and it also imposes a substantial obstacle on access, then that regulation would be unconstitutional.
Okay, got it. So just to summarize, what it sounds like is we have established that abortion is legal in this country, but it can be regulated under certain circumstances, and that is done at the state level.
Yes.
Right? Okay, so in Virginia, who does that? Who regulates abortion?
Okay, so in Virginia, generally, the legislature here has the power to enact laws that the governor can either veto or sign into law that regulates how any kind of medical procedure is performed or who performs it. And that includes abortion. Okay. But they also have the power to direct the Department of Health, which is a state agency, to enact regulations that kind of get into specifics about really who can provide an abortion, what kind of facility is it provided in, what kind of standards, kind of specific requirements are there for that facility to have continue providing that type of medical care. So those regulations are enacted by a body of 15 medical professionals that compose the Board of Health, and those medical professionals are appointed by the governor for a 4-year term.
Okay, great. So what would be the reason, I mean, obviously there are proponents of restrictions on abortion. I mean, what would be the reason why abortion providers might need more supervision or regulation to make sure that they are following the standard of care?
There isn't really a good reason to be holding abortion providers specifically to enact rules that make sure that they are doing their jobs correctly.
Right.
Basically, abortion is one of the safest medical procedures that's performed in Virginia. The Center for Disease Control shows that first trimester abortions are 99% safe. It's safer than getting a shot of penicillin.
Okay.
And it's really, as long as the medical provider is appropriately trained, it can safely be performed in a regular doctor's office or an OBGYN office. So there isn't a real reason to regulate abortion.
Single them out.
Right, to single them out for different treatment. And one of the important things to remember is that the medical profession is very highly regulated by what's called the standard of care, which is enforced by state statutes and regulations by the Board of Medicine and the Board of Health Professions, which basically says that any type of physician or healthcare provider, like a nurse or a physician's assistant or a midwife, have to follow certain rules. And that means that they have to stay up to date on their training, and they have to make sure that their staff is appropriately trained and screened. They have to make sure that the facilities where they perform medical care for their patients are clean and that they're safe, and that if a disaster happens, that they have a plan for how to have people leave the facility safely.
Right.
So if a doctor or a medical professional doesn't follow that standard of care, then they can be sued for medical malpractice.
Disciplined.
Right, they can be disciplined by the Board of Medicine or the Board of Health Professions. So there are lots of structures in place in Virginia and in every other state that make sure that physicians and other types of medical providers have to provide high quality, safe care for their patients.
Right.
And abortion providers are no different from the rest of physicians. They are subject to the same standard of care rules, and they're subject to, of course, discipline or lawsuits if they break the standard of care. So when you look at the incredible safety of abortion procedures, and also consider that abortion providers are the same as other types of healthcare providers, and they're regulated the same, there isn't really a good reason to be imposing special rules and regulations on just abortion providers.
Right.
And especially in Virginia, there are types of doctors and procedures that are riskier, that are less safe than abortion, that aren't subject to special regulations.
So why would anyone argue in favor of these type of regulations if they don't serve any practical purpose?
Well, the reason why these regulations were enacted in Virginia in the first place, and the reason why over 26 states have enacted what we call TRAP regulations, targeted regulations that only govern abortion providers, is frankly to cut off access to safe and legal abortion in Virginia. These laws are structured as a sort of double-edged sword. They're designed to shut down trusted women's health centers who have been providing safe, legal abortion, high-quality abortion care, and other comprehensive range of reproductive health care, like access to contraception, STD screenings, throughout Virginia and in other states for almost 40 years. And basically, their TRAP laws are designed to shut down clinics like that, but then also make it impossible for a regular doctor or an OBGYN who's been trained to perform abortions to incorporate that into their regular practice. Like if they're running a standard family healthcare practice that you might go to for your annual physical, those doctors could have training to perform abortion and they could do it in their office, just like OBGYNs perform pregnancy terminations in their office. So these laws are really designed to cut off access to safe and legal abortion, which puts women's health at risk.
Yeah, and we'll talk about some specifics of what some of these regulations have imposed, but just generally, it's cost prohibitive. If you're running a facility and you have to comply with these laws and retrofit your office, or you're building a new office that has certain requirements, it just doesn't, it's cost prohibitive. It's going to put you out of business.
Right, and that really is what happened, or what was calculated to happen here in Virginia in 2011.
Right, let's talk about that.
Sure.
Something happened in 2011. What was that?
Yes, so in 2011, well, I guess prior to 2011, there had been a growing concerted effort among some of the more conservative legislators in Virginia to enact laws that cut off women's access to safe, legal abortion care. And by 2010, in Virginia, those legislatures that were looking to enact anti-abortion legislation had gained control of both houses of the Virginia legislature. And then they also had control of the governor's office through former Governor Bob McDonnell. So at that point, Virginia was prime for enacting anti-abortion legislation that was designed to shut down clinics and was designed to make it difficult, if not impossible, for women to access abortion care here. So the way that this played out was there was a bill in the 2011 General Assembly session, which our General Assembly, our legislative session in Virginia lasts between 6 and 8 weeks, and it starts in mid-January. So during that legislative session, there was a bill, and it was originally an innocuous bill. It was designed to make sure that nursing homes, nursing care facilities had to follow appropriate infection prevention procedures, and that they had certain disaster preparation plans in place. And so this bill got through the House and got through the Senate, and then when it was in the Senate, there was an amendment, a last-minute amendment to this bill. And that last-minute amendment said that abortion facilities, which were defined as any medical facility that provides more than 4 abortions per month, had to be regulated like hospitals.
Right. And
that also meant that they had to follow the same architectural requirements as hospitals.
Such as?
Minimum hallway widths that are designed to allow 2 gurneys to pass in the hallway. And if you're providing surgeries, that makes sense.
Sounds reasonable.
But for abortion care, there's no gurneys involved. It's simply not something that's part of abortion care.
Right.
But also certain numbers of water fountains, having procedure rooms that were a certain size, ensuring that there were enough parking spots calculated based on the square footage of the facility.
Right.
Things that make sense when you're regulating a big hospital that's performing invasive surgical procedures. But regulations that don't necessarily and don't make sense when we're talking about abortion, which is a non-invasive procedure that's performed in a non-sterile environment. It doesn't need to be performed in an operating theater.
Right.
So those types of architectural requirements were imposed on abortion facilities. And additionally, there were kind of a slew of other requirements that kind of went along with saying that abortion providers needed to be regulated like a hospital. So you have bureaucratic paperwork having to produce very standardized operating procedures that again would make sense in a hospital that don't necessarily make sense in what's really just a regular doctor's office.
So we're probably going to get to this, but what does the medical community have to say about this? I mean, the people passing these laws for the most part are not doctors. Did they hear from medical professionals about this, and what do they have to say?
So that was the interesting thing about this this kind of last-minute amendment to that nursing home law, is that there was no time for the public to comment on that amendment. The legislators did not hear from the medical community. They did not hear from the public about whether this was a medically necessary restriction on abortion. They just passed the law, and then Governor McDonnell signed it. So what the statute that was passed directed the Board of Health to enact regulations implementing this directive, which is saying, okay, you have to regulate abortion facilities like hospitals. We're going to leave it to you to work out the specifics of that. So what ended up happening was the legislature told the Board of Health to create some emergency temporary regulations, which is normally, that procedure is normally only required when there's a public health crisis. Right. There was no public health crisis. The clinics and other providers that had been providing abortion in Virginia for decades had always had a great track record of being safe, and Virginia was
incredibly safe. There was no problem that was being solved here, right?
No, there wasn't any problem being solved by enacting this statute. But the Board of Health has its directives from the legislature, so the Board of Health convened a committee of OBGYN, heads of OBGYN departments from hospitals across the state, and this committee came up with rules and evaluated those draft rules to say what was medically necessary and what made sense. And what this committee said was, it doesn't make sense to require existing abortion facilities to follow these architectural standards, because for one thing, those standards aren't even required of existing hospitals. So when those standards come out and they're released, they're periodically updated. A hospital doesn't have to overhaul and remodel every time there's a change in what's essentially like a building code for hospitals. That's basically what's being followed here, because they have, it's called being grandfathered in. So like if you're an existing facility, you don't have to overhaul every time they're changing a building code, and that's true of basically any kind of structure that's subject to a building code. You don't have to change every time a new version of the building code comes out. So that committee of OBGYN specialists said it doesn't make sense to have to require these existing facilities to spend what was calculated to be hundreds of thousands of dollars.
There's no medical benefit to doing this.
Right.
So, but in terms of impact, let's talk about what this has done to access to abortion across the Commonwealth.
Well, what ended up happening is that the Board of Health didn't listen to this committee. Instead, they were pressured by former Attorney General Ken Cuccinelli, who maintained that the statute, the TRAP statute, required all existing abortion facilities to comply with these new architectural regulations. And he knew full well that meant that these clinics were going to shut down, that most of the clinics in Virginia would shut down or be forced to stop providing abortions if they had to comply with these architectural requirements. And the board did it anyway. The board was essentially, in a way, bullied, threatened by having personal exposure to a lawsuit if they didn't enact those types of regulations, and they didn't subject existing facilities to these, what at the time were the most burdensome regulations on abortion providers in the entire country.
And it worked, right? There were actually facilities that closed as a direct result of this.
Yes, at least 3. So prior to 2011, there were 21 abortion providers in Virginia. At least 3 of them shut down as a result of these TRAP regulations, or in anticipation of them. And then there was another 4 that shut down for partially because of the regulation, also because of other reasons. So we've already had reduced access to abortion in Virginia. And also another thing to point out is that if there were providers, OBGYN offices, or regular family care providers that had been providing more than 4 abortions in their practices per month, they had to stop doing that.
Right.
And the only way that they could continue to do that would be as if they registered as an abortion facility. And we know that they didn't do that.
Right.
So there could be a bigger access crisis that was created by these laws going into effect than even the numbers that we have show.
So if you're a woman in far southwest Virginia or rural areas in particular, I think are affected by this, correct? Because we're talking about geographic distances that cause a problem, cause a barrier.
Yes. So over 9/10 of all counties in Virginia do not have an abortion provider. And this also needs to be put in context because these trap regulations were passed at a time when there was a wave of anti-abortion restrictions, laws being passed, not just in Virginia, but throughout the country. And so there were providers shut down in rural areas, and one of the biggest providers, abortion providers in the state was actually in Northern Virginia, in Fairfax, which is a suburban/urban area, and that shut down, right? So there was a huge decrease in access just by that center shutting down. But there also, especially for women that are living in these rural areas in Southwest Virginia, that it may take them 5 or 6 hours to drive to a facility that provides abortions. Not only do they now have to drive further, but they also, thanks to a law passed in 2010, if they have Medicaid, if that's their health insurance is provided by the state, meaning they're living in poverty, then Medicaid doesn't cover abortion in Virginia anymore. That was in 2010. Then in 2012, we had a law passed that I think there are many people watching that probably heard about this law. It was the transvaginal ultrasound bill. It made national news, and it was amended to just require any type of ultrasound, which could be a transvaginal ultrasound, meaning an internal ultrasound, or an external ultrasound that are more like the ones you see on TV, where the wand is sort of over your abdomen. That needs to be performed 24 hours before a woman can have an abortion. So unless you live less than, more than 100 miles away from an abortion facility, that means that you have to take 2 trips.
Or spend the night,
yes.
Take time off your job.
Find childcare.
Right.
Exactly.
Making it very hard.
There are many, many women in Virginia, or transgender men, or gender nonconforming people. Those are also people who need abortion care.
Sure.
That don't have sick days, that don't have time off from work, that couldn't explain to a boss, I need to take 2 to 3 days off.
Right.
And also an extreme percentage of women who seek abortion in Virginia already have kids. So this is their 3rd or 4th pregnancy. They've decided that they need to terminate for their own personal reasons. Right. Then they have to find childcare. And I think that it's been in the news enough lately. We all know how expensive childcare is, how difficult it can be to find last minute for something like this. So, and then also in 2013, Virginia, Governor McDonnell signed into law that any insurance plan, a private insurance plan that's purchased on one of the Affordable Care Act marketplaces cannot cover abortion.
Wow.
So not only do you have the cost of traveling, finding childcare, taking time off work, you don't have the procedure covered by insurance. For women and other patients that need abortion who are at the most risk of not being able to afford all of these things, like on top of that, they're the ones that are most at risk for not having insurance that covers the procedure.
Right. Okay, so there was another Supreme Court ruling that came down, I think, this summer, right? Can you talk about that a little bit and how that plays into this situation?
Yes. So, I mean, one of the other important things is that after these regulations went into effect in 2013, the Board of Health said, okay, abortion facilities have 2 years to bring their facilities into compliance with these architectural requirements. But in the meantime, Governor Terry McAuliffe was elected in 2013. And Governor McAuliffe, together with Attorney General Mark Herring, are very strong advocates for protecting women's health. And so they got involved in the TRAP dispute. And Governor McAuliffe made a commitment to appoint board members to the Board of Health who were going to put women's health and safety above politics. And he asked the Board of Health to reevaluate the TRAP regulations and to amend them to the extent possible, given the limitations of the TRAP statute, so that they were more based in medicine and science than politics, and that they imposed more reasonable restrictions on women's health centers, with the idea that they would keep those centers open. And then also Attorney General Mark Herring issued an opinion stating that existing women's health centers did not have to comply with the architectural requirements. So that kept clinics open, which was very good. In Virginia, we were able to keep the clinics open. But we were in the process, in the meantime, when all of this was happening, starting in 2011, the ACLU of Virginia kind of led the creation of a coalition that involved our partners, our reproductive health care advocate partners like Planned Parenthood, NARAL Pro-Choice Virginia, the National Latina Institute for Reproductive Health, and the Virginia Latina Action Network, and Progress Virginia, the National Abortion Federation, the Center for Reproductive Rights. We all got together and brought in abortion providers, OBGYNs, medical professionals, advocates, volunteers. This coalition became really an army to fight against these TRAP laws. And that involved pressuring the governor and pressuring the Attorney General's office to make sure that the regulations that were in place were based in medicine and science and weren't just political calculations to shut down abortion facilities. So as that was happening, there was we were on the way to getting the worst of these regulations amended to be slightly less onerous and to keep clinics open. That was the main point of that. So by September 2015, those regulations were on their way in place. But then in June of 2016, earlier this year, the Supreme Court of the United States decided a case that was based on similar TRAP laws in Texas. The law at issue there was called HB2. And HB2 had almost identical architectural requirements as Virginia. But HB2 also had a second requirement that made doctors have to have admitting privileges at hospitals within a certain distance of their clinic where they performed abortions, or the facility where they performed abortions. And those two requirements put together shut down more than half of the existing clinics. And if basically the admitting privileges requirement was allowed to go into effect, shutting down about 20 clinics. And there was a court blocked the surgical, what we called the surgical center requirements, which was basically the architectural hospital-like requirements. Those were put on hold, but if they had been allowed to go into effect, Texas would have been left with between 7 or 8 providers to serve over 5.4 million women.
Huge state, right?
Yes. I think that it's like 280,000 square feet or square miles, I think. Yes, miles in Texas, where there are some women that would have had to travel 8 hours one way in order to get to an abortion provider. And that, in and of itself, it created a public health crisis. Because when women don't have access to safe, legal, quality, affordable reproductive health care, including abortion care, then that's not going to change the need for abortion. It's not going to change a woman's mind. Once her mind is made up, the real question is, are you going to make sure that she has a safe, well-trained physician, medical provider to perform an abortion for her, or are you going to leave her to her own devices, which, as was shown in Texas, could mean...
It's horrifying.
Yeah, I mean, it could lead to a woman dying. It could lead to permanent medical conditions, or someone not being able to have a child, a planned wanted
It's
child in the
essentially
future.
pre-Roe v. Wade type conditions.
Right. You're putting women's lives at risk.
Right.
And you're forcing them to make decisions that are, instead of being empowered decisions, that allows them to do what's best for their lives and their families and according to their own morals or their own religious beliefs. You're imposing other people's morals, other people's opinions and religious beliefs on them and preventing them from being able to make the decision that's best for them. So given that situation in Texas, that ended up going up to the Supreme Court of the United States in a case called Whole Woman's Health v. Hellerstedt. And in Whole Woman's Health, the court was faced with that undue burden standard that I mentioned earlier, which says that a state can impose restrictions on first trimester abortion that are supposed to improve a woman's health, so long as they don't impose an undue burden on access.
Making it too hard to be able to get it.
Right. So the big question was, Texas claimed that both of their laws, both the architectural requirements that were just like the ones at issue in Virginia, and the admitting privileges requirement, even though anyone can go to a hospital emergency room and get treatment without a physician who performed a procedure that they're having to go to the emergency room about. Like, you can go into any emergency room and get treatment without having your personal medical provider have admitting privileges there. But Texas was saying that both of these laws were necessary to protect a woman's health, that's why they were passed, to protect healthcare, to make sure that women had the best healthcare. But they didn't have any evidence to back up what they were saying. And instead, there was just a tidal wave of evidence showing the contrary, showing leading medical organizations like the American Congress of Gynecologists and Obstetricians, which is the governing body basically of OBGYNs in America, the American Medical Association, all said that abortion is incredibly safe. It does not need to be provided in a facility that's the equivalent of a hospital or an ambulatory surgical center. And also that it was not necessary or practical to require an abortion provider to have admitting privileges in a hospital, which, by the way, can be denied if the hospital just doesn't agree with abortion or thinks that it would be too political to have an abortion provider with admitting privileges there. So when you have that incredible imbalance over the state just claiming this is necessary to protect women's health versus all of the medical and scientific evidence saying no, it's not.
This is basically the same thing that happened here, right?
Yes.
Okay, so we had this case that came down. Then what happened following that in Virginia?
Well, I mean, what resulted from Whole Woman's Health was a changed standard of review. So the Supreme Court provided guidance for courts to evaluate abortion restrictions to determine whether they were constitutional. And what the court said, that an abortion restriction is necessary to protect women's health, they have to prove it. They have to prove it through scientific evidence, through medical evidence. They can't just say that it's that and then and that's enough. They have to do more. And then secondly, that if a restriction does have a medical benefit, so you could say, well, we want women to be as safe as possible, so we want to take every single possible measure to make sure that this is done in the most safe way possible. Okay, that's fine, but if the medical benefit, so if the difference between providing an abortion in a doctor's office that's 99% safe and providing it in a hospital where it's 99% safe, there's no difference in safety between providing it in those two environments. So if there's the medical benefit arising from requiring abortions to be provided in a hospital is not greater than the burden that's imposed on women for having all of their health clinics shut down and not being able to access abortion care, then that's an unconstitutional law. So basically the medical benefit needs to be greater than the obstacle that is put in place between a woman and her ability to access safe legal abortion care. Right. So basically when that opinion came down, when that case came down, that coalition, that army of reproductive justice fighters, pressured the Attorney General's office in Virginia and the governor's office to roll back our architectural requirements and to also change the overly burdensome, medically unnecessary regulations that were imposed on abortion providers, but were not imposed on regular doctors or OBGYNs that were performing the really same type of medical care, same type of procedures in their offices, because you're not showing what's the medical benefit here of requiring abortion providers in Virginia to perform abortions in a hospital-like environment. The Supreme Court said that identical requirements in Texas weren't medically necessary,
right.
And that they didn't outweigh the burden. So it was an easy case to make in Virginia to say that our requirements also were not medically necessary, and that they should be overturned.
And so there was a vote recently, right?
Yes. So on this past Monday, October 24th, the Virginia Board of Health historically voted to roll back our TRAP restrictions. They amended or repealed the most onerous of the abortion provider regulations in place in Virginia. So this will ensure, for the time being, that women's health clinics stay open, and it's going to make it easier for physicians or OBGYNs to incorporate abortion into their everyday practice, which we hope will increase abortion access in Virginia.
Right, that's fantastic, and I just want to say thank you to you and to the rest of the partners who worked so hard on that effort. And I have one more question, but I just want to give anyone who's watching a heads up that you're welcome to ask questions. If you just want to type those into the comment section below the video, we'll get to those once we're done with the discussion. So what's next? I mean, that all sounds good. It's progress, and that's good, but what's next? That's not the end of things.
No, certainly not the end of things. So the Board of Health amending the existing regulations is really more of a Band-Aid. It's not a permanent solution, because there is still a statute on the books in Virginia that says that abortion facilities are a type of hospital and they need to be regulated as such. Mm-hmm. So in order to make sure that, for instance, a new governor that comes in after the 2017 election may say, I want those more stringent requirements back on the books, and I'm going to appoint members to the Board of Health that will put them back on the books. And they would be able to do that. That's the same way that we were able to get them rolled back. It really is more about the political powers that be at that time.
Right.
So what really needs to happen is the Virginia General Assembly needs to repeal the TRAP statute. Mm-hmm. And they have more than enough guidance from the Supreme Court of the United States to support doing that. And if they don't do that, then there may be other avenues that reproductive rights advocates and attorneys may need to take in order to get that unconstitutional law off the books in Virginia, and other states will be doing the same. And then also looking at the whole women's health decision and determining whether existing abortion restrictions within Virginia and in other states would pass that new standard.
Right.
You know, is the medical benefit of these restrictions greater than the obstacle that they impose on a woman seeking abortion? And I think that question's in the air right now.
So for anyone watching this who's concerned about the situation and the future of abortion access in Virginia, what can they do?
Well, they can contact their legislator. If you live in Virginia, you can contact your state senator or your state delegate and say, I want this law off the books. You can also participate in the public comment period that will be happening for the recently passed amendments. Essentially, they're going to go to the governor to be approved. Then there will be a 30-day public comment period, at which point citizens in Virginia can voice their support for women's access to comprehensive reproductive health care and support the Board of Health's decision to amend these laws so that they are more reflective of the standard of care, more reflective of actual evidence-based medical care. And then, the other thing that you can do is vote, because the Supreme Court of the United States has a vacancy right now, and there's certainly a chance that we can have even greater protections for reproductive rights and women's bodily autonomy, anyone's bodily autonomy essentially, through the Supreme Court. So it's an important election, and you can do your research and you can determine which candidate is going to appoint justices that are most in line with reproductive rights.
And of course, we don't tell people who to vote for.
Certainly
But we would tell people on any issue to do your research and understand what the candidates' positions are and vote accordingly.
Right,
so,
right.
And so, for your state legislators, their voting record on these issues is a matter of public record, is available online.
Right.
You can write or call and ask them and let them know how you feel.
Yep.
Also, we would encourage you to follow the ACLU of Virginia on social media, on Facebook, on Twitter, and also, most importantly, to sign up for our action alerts on the website. When there's a bill coming down the pipe, when there's something important that's happening with this issue in Virginia, we'll let you know. And we can make it very easy for you to let your legislator know how you feel. Very simple forms that are set up. You can go online in 30 seconds, send a message, and it'll go to the right people. And we found those to be very effective, and we really rely on your support for that.
We certainly do.
Okay, so let's take a look. I don't know if we have any questions. Okay, no questions at present. One person asking if we're going to publish the transcript so others can learn and be more effective on this issue. Not a transcript probably, but this video will be maintained on Facebook, and we'll post a full version on our website as well. So if it's something that you would like to share with others in your networks, we would very much appreciate you doing that.
Yep. And we also do have a blog on our website right now. It's also on the National ACLU's website that gives an overview of the TRAP process in Virginia from start to finish, that you can also consult for some of the same information that we communicated here today.
Well, Gail, the critically important issue, we're very lucky to have you on board to be working on these things every day. Anything that you would like to add?
Just, again, encouragement, get out and vote, and don't be afraid to contact your elected representatives and hold them accountable for the decisions that they make, because this is a really important issue. It is a controversial issue, but at the end of the day, if you care about women's health, if you care about anyone's ability to access necessary reproductive health care, this is an issue to stay engaged in and to learn more about. So. And your elected representatives do need to hear from you. And
I think one thing, just in closing that we found is this is sometimes not an easy issue to talk about. So, finding folks, within your networks, friends, family, where you're comfortable talking about these things and encouraging awareness and sharing of these issues is very important as well.
That's true.
Okay, well, thanks so much for joining us. Again, we'll retain the video online and ask you to share that. And join us again next time for our next Facebook Live.